defending the voiceless, the wrongly accused, facing the foe whose motives are abused. In the courtroom battlefield, they'll stand tall, unveiling corruption. They'll conquer it all against the corrupt prosecutors' wrath. Words like weapons cutting like a path, challenging the system that's filled with lies, seeking truth with justice in their eyes.
Heyo, folks, and welcome to day 128, part 2. We were rudely interrupted after morning break with the judge declaring, I'm sending the jury home, and you can recall your witnesses tomorrow morning, Ms. Love, and we will be back at 2 p.m. Attorney Adams. I took I took the main attorneys in this. So yeah. Now I have no issues if anybody makes a compilation of all the attorneys. But for, I don't know, I'm not a person that can talk about aesthetics, but I mean, the 6 defendants, 6 lawyers, their main lawyers, that's what I thought. But you do AI pictures or draw something and DM me on Twitter, and I will do something with it. I promise. So we are currently waiting for them to come back. And I have the live on, I have the sound on. She said 2 p.m. And the only thing I've heard, let's see here. Dun, dun, dun. I think Kathy Russell had it. Kathy Russell from Law and yeah, this is what she says. Oh. Took a morning break, and then judge attorneys went to a sidebar with our camera ordered on the seal, no audio. There's apparently an issue with the juror. The jury has been dismissed for the day. Parties will be back 2 p.m. to argue other matters. Jury back tomorrow with witnesses. So that is the information that is relayed. Hopefully they will be, because this is a part of the trial. A very important part of the trial is the number of remaining jurors. So why would this be excluded? Now, they don't have to go into specifics. Just tell us. Because it is information that shouldn't be withheld from the public, in my opinion. So yeah, we are currently waiting for everything to start up again. And yes, then something very sad information is for you who know, I covered this case. Let me show you. This is Missouri versus Marcellus Williams. He had his last chance of providing evidence for his innocence on August 28. And one of the main thing was the retesting of the DNA samples, or crime scene DNA sample. And sadly, that DNA sample was contaminated. And once you're found guilty, you have to prove your innocence. And yeah, he failed at proving his innocence, even though most of everything that the prosecution brought forward in that case was either exaggerated or plain lies. But on September 24th, Marcellus Williams will be executed in Missouri. And yeah, it is, yeah. Yeah. Hopefully, Mr. Williams has prepared himself for this being a strong possibility. But in my opinion, the state of Missouri and the Attorney General who refused to follow procedure on September 24th will murder an innocent man. And I don't know what deity he confesses to, but I assume whatever it is, when his soul is measured, this he will not be able to explain away. All right. They are back. They are back in the young Thug Rico trial. So let's see what we can find out here.
Is that the only area? I know this one. Okay.
Okay, everybody's getting seated, I assume. Yeah, regarding the death penalty, I am on principle against it. Even no, my objections are either loud from the rooftops, or it is whispered in the privacy of my home.
Get together and get some things settled to get on the same page with exhibits and things? Do we have any kind of?
With the exhibits, I spoke with Mr. Adams, and we agreed to exchange physical copies at 2. That was the suggestion, and so we're gonna do that. I did have an opportunity to speak preliminarily with some of the attorneys about the other matters.
Okay.
And so those are we're working on those.
Good.
And Miss Knight is headed over with the last page of the exhibits that we have, and we're going to exchange the 2, and we can continue to compare.
Okay.
Sounds like Miss Love was stalling.
All right. So if we're not quite ready to go through that, which it doesn't really make much sense to do before y'all have had a chance to see what you are on the same page about. Then do we want to maybe keep going through the wiretap evidence, or, because y'all were going to also get together on some of the Mr. Ryan evidence, so I'll give y'all a chance to do that as well.
Right. I've only done part of that.
Yeah, no, I know. And I mean, I was going to give you some, I know that we're having this unexpected non-jury day, so I don't expect y'all to have already accomplished all of that, but I don't want us to just waste time since we're here already. So one thing we can do is just skip over that one issue that you asked for a little more time on, and oh, but you also haven't really had time to narrow down what else you think is on here. Okay, so what do we still need to look at that is not this either, but that is evidence? I didn't think about that.
I'll let them respond. I'll see what they're-
I'm listening.
When you said not this either, what is
Oh, sorry. So the list of all of the various parts of the wiretaps that the state wanted to introduce, remember yesterday I encouraged them to further narrow that down, and obviously they haven't had a chance to do that yet either, so I don't want us to go over things that we might not ultimately need to be discussing.
And I'm just putting this on the radar. I don't have any anticipation that the state is ready to do this today, but I'm just, for my periodic reminder, there's issues with my client's cell phone was extracted, and there's issues with any texts or any information extracted from my client's cell phone. That was in 2022, so that's involving the Shamal drinks case. I brought that up a couple of times, and the state said that they're going to identify those items. They haven't yet. I'm not complaining. I'm just trying to replace that on the radar
Thank you.
for some later time.
Okay.
And Your Honor, I just want to make certain it's just the identification. There's not like a suppression or anything motion on.
You just want to know what all they're going to use?
I did move to suppress the search of my client's phone, but that was denied by Judge Glanville. So, you know, there's just a lot on my client's phone that has nothing to do with this case. There's bad character stuff. There's,
Well, I would hope if it has nothing to do with the case, that the state doesn't intend to use it, but
from my perspective, it has nothing to do with the case. I'll put it like that. And so
The state don't intend to use bad character. That's funny, Your Honor. That was funny. Oh.
So at some point, anything that the state plans to use as far as text messages, things of that nature, that needs to be litigated.
all right, when can the state do that?
I think that in the same way we're doing with Mr. Ryan, we can schedule, Mr. Sharp and I can talk about when he's available, and we can actually go through it whenever, like this weekend.
I'm not trying to buff Ms. Love's offer to sit down with her, but it would just be.
It doesn't have to be
helpful.
me, just
Well,
somebody.
it's not you. It's just, if the state could just identify what they plan on using, and then I could look at their list and then figure out.
Okay, so
Thoughts on
can you get,
About Ms. Love personally, it's just sitting down with anyone going through my client's phone. I just think if they go through it and figure out what they want to use and let me know, then.
and then you can maybe, okay, sort of like y'all done with some of the other things. So if you can, when can you provide to Mr. Sharp the proposed list, I guess?
We need at least to try and whittle it down. We need at least through next week. So no sooner
All
with.
right, so by next Friday, you could do that?
Can we have until next Monday?
By the following Monday,
Yes,
the 23rd?
yes.
Okay,
That's fine. And Your Honor, these are probably when I think about it, the sequence of charged acts, these are at the very end. So if we're going
Well,
sequentially.
I mean,
would
that's
assume-
fine, but
Yeah, I'm
we
just-
still have to do it at some point, and so probably the sooner they can get it done and get it to you, and you can, y'all can maybe agree to certain things, maybe not, I don't know, but then we will have it available to litigate whenever we do have another non-jury day. So
Absolutely.
thanks for getting that put on the list. Appreciate it.
Yeah,
What
it's
else are we gonna still need to look at? What other kind of buckets of evidence that we haven't discussed yet?
It seems like we will not find out what the jury issue was. Now, if this jury issue is severe enough for the juror to not continuing their participation, then they kind of have to tell us. But it seems like they won't until then.
What do I got? Phones. I'm thinking, Judge.
Okay. And I mean, one thing,
Oh, the closed captions.
I'm thinking, Judge.
okay.
Ah! Oh, the closed captions is here to save the day. Oh. Oh. Oh.
And I mean, one thing we had done at some point, and I don't know if we got all the way through it, but the state had provided everybody with this order of proof and exhibits. Did we get all the way through that? Because that might help trigger, oh, this is something we're going to need to litigate. If y'all got those available, maybe we could look a little bit further through those.
I can get a copy and just for the court's awareness, we just got those printouts that I'm going to exchange with Mr. Adams. If we can be allowed to, the exhibit list printouts that I referenced
Okay.
earlier.
Yeah, I think Louis Thomas in chat is correct. Love will have nothing ready because she
I don't think
never
we've
has
gone all the
anything
way
ready
through this.
unless it's something the defense might have done. And we are up to live. And they are looking at evidence together. Now, I don't think this is a hot, well, it could be a hot mic, but yeah. So, hey, how are you all doing? How are you all doing? Hope you're doing fine. Do we know the reason, any reason N.Starow will never send anything digitally? It's harder to manipulate something if you have to send an actual copy of the original. I mean, there are 5 prosecutors on their team, and nobody is preparing anything just in case, even though the judge told them to. No, not one. 5 full-time prosecutors paid by the taxpayers of Fulton County. Louis Thomas says attorney was smart for not sitting down with her. She cannot be trusted. Absolutely not. Any meeting with the prosecution should be recorded. I definitely wouldn't have a meeting with these prosecutors without recording, just to make sure they can't lie about it in court. Mr. Harvey has to stew in a little over there. Never got to argue his motion that should have been brought up a long ago. Yeah, I agree. Denise sells. Miss Lowe wants everybody to do her job, then write it down for her. then she wants to have the whipping horse to blame for her incompetence. I think it's the other way around. She doesn't trust the other prosecutors to do her bidding anymore. And they might have said, we are not helping you anymore with you embellish and lying. Yeah. So this is what is going to happen the rest of the day. Yeah, she actually was.
Y'all aren't actually doing the comparison right now, are you? Okay, are y'all gonna be finished with whatever it is you are doing soon? Okay.
I mean, no matter what, the judge has the authority to simply say, you know what? I know I gave you until
Okay.
Monday, but give me what you have now. They had 2 years.
So if everybody has access to that list that the state had provided a while ago with their kind of a chart of the witness testimony and exhibits, I don't think we went all the way through it, and that might help everybody to think about if there are other types of evidence that we're going to need to still handle kind of motions in limine on. I know we'd gotten through.
Yeah, why not have a bunch of those? Because any prosecutor should be able to argue by heart what to say, not say, case law. Because that's what the taxpayers are paying them for. They only do this trial, this case. Now, the defense attorneys are more or less working around the clock to great cost of their clients. Except Miss the Williams client, because she is a public defender, but it's just her for $5,000 a month. Oh, that poor woman is going to be bankrupt before this. It's Trinton. I have a question for other research nerds that I couldn't find the answer to. Is there an expatriation on a subpoena when the witness isn't called? System is not designed for cases to go on and on. I don't know. Because this is a unique case in its length or expiration. It should be. It really should be. That's a really good question. Really good question. I will ask someone who might know. When was Lil Wayne's subpoena handed to him? Anybody knows? He was on the witness list, even though they have no intention of calling him on the prosecutions. All right, I sent.
At least proposed witness 24, maybe 26. I don't know if we'd gotten much further than that.
Yeah, any subpoena will probably expire by default after this trial is over. But then again, there are more trials that is connected to this one. It's just that it is severed.
Let me know when y'all all have it. Okay. So it's on page 6 at the top with Turner. I would assume y'all have seen all the crime scene photos. Do y'all know, do you, the state, know which ones you're intending to use?
So page 6.
I mean, have y'all gotten together on things like that? Like, okay, here are the, 25 or 10 or whatever crime scene photos that are going to be used with crime scene tech Turner and.
I don't believe that our team has gotten with the defense on those.
Okay.
There is.
Of course they are. Denise else, Nick, do you think having these platforms allows lawyers to say some of the things they really wanted to say while in court? Yes. I can guarantee you this language is nothing I use with clients, with party opponents, with negotiations on anything like that. I'm really stoic in negotiations. And when I mean it's according to this statute, according to that law, according to your own admission, according to blah, 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 blah. Almost monotone, because it drives people crazy.
We had been, and we advised them that we had been told since 2022, I think, that there was a set of photos from Adele Avenue that we didn't have. They said it was lost in the hack. We have been persistent, and Mr. Brown has somehow or another gotten somebody to put their hands on a flash drive that has photos in it that he received this morning from APD. We have the emails from between all of us requesting that they go find some physical copies. We brought this to the court and defense's attention several weeks, maybe a couple of months back, that we didn't have them. They said they didn't have them, and we just kept asking, and somehow somebody found a flash drive.
That happens sometimes.
I can't make it up, but he has them, and I don't know that he's sent copies of them, but we can have copies brought over. That's just a matter that, since we're in the middle of that, I think they need to have and see.
Okay.
And so we'll bring that over as well if it's not already been sent over via a link. It may have been sent over via a Dropbox link.
Okay.
But we've not yet gone over the individual pictures and told the defense which ones we will and will not use. I can get the prosecutor, who will be Mr. Brown. I can get him over here and we can have a conversation with a member of the defense, just one, so they can share that, because he's already taken those out and just made that decision.
Can you have a member of your team go ahead and reach out to him and Can he maybe come over today?
Yes, and yes.
Okay.
Yes.
Yeah, isn't that strange? The hack that the state blames all the time did not destroy things you want to have because they had backups, but things beneficial to defense didn't have backups. It's weird how that hack only affected evidence that might come to use to a defense. Really, really strange. Really, really strange.
And we honestly may not have gone witness by witness up to page 6. So if you look back and see something on the first 5 pages that we haven't covered yet that y'all feel needs to get litigated, let me know. Or if you don't yet know kind of more specifically what that evidence is going to be and need to, let me know.
I'm reviewing that now.
And for all of the photos, like with Miss Bell today, you introduced, I think, 4, but you only used 1. I mean, to the extent, you can continue that sort of thing where it's not cumulative, then that's fantastic. Thank you for doing that.
Thank you, Chairman. Yes, you're welcome. Thank you.
Ooh, let me show you something while we wait. Look at that. I'm 128 subscribers from 10,000 subscribers. If we reach 10K next Friday, not this Friday, next Friday, will be an Ask Me Almost Everything panel show. Members can submit their questions on Discord or via DM or something like that, or in the commentary to the Discord link and stuff like that. The rest of you have to wait. And the guests will have 1 free question. And 20th, yeah, Friday the 20th. So that is what is going to happen. Now, if there is a question, I said almost everything because, as you know, I have attorney-client privilege and all of that, and can't ask me about work unless I can answer it in generalities. That's not how this works. When you get 10K today, you have some wheel of misfortune. Yeah, I have work tomorrow morning. My alarm clock goes off at 4:30 a.m. as per usual. So I cannot do the wheel of regrets. Let's get back to this.
There is one witness whose attorney, I'll just apprise the court and counsel that may be coming up. Mr. Arnold, I've been in touch with his Ms. Merchant. And so that I see that on the list of my.
Did she say Miss Merchant? That would be Mrs. Merchant, first of all. And
Sprinkle exhibits if it's necessary for impeachment.
Can y'all hear her?
I'm sorry. I've just been in touch with one of the co-defendants' attorneys. I see his interview on Mr. Sprinkle's list of exhibits if it's necessary to use, because I've been talking with her about him coming up relatively soon. I have not gone over his interview. I don't think we've gone over his interview at all, but it would only be used for impeachment purposes in any event. But if that's something that I'll have to discuss with the defense in terms of things that they believe that are, impermissible, inadmissible. But that's something that's on the radar.
Okay.
So can I inquire? And I believe I'm looking at the same document as everyone else. For number 8, Michael Sprinkle, it says jail calls, pictures of infinity, social media, and interviews. When we're saying interviews, Mr. DA Sprinkle is kind of a unique witness in this case because he's a DA, but he also, I think it's fair to say, he fulfilled a certain investigatory role mid-investigation. However, he wasn't sitting when it says interviews.
Let's get some clarification on that. Are these interviews that Mr. Sprinkle conducted of people, or what are these?
Yes, and it's also detailed in the report that we provided that he gave that 146 page, 136 or 46 page report. So there are interviews that
I'm quite certain on the Daubert hearing, or the hearing, so to speak, he only received, now he might have sat in on an interview or two. This is strange.
law enforcement conducted in 2015 and 16 that he would not have been a part of. As a result of further investigation that he did, he would have gone out to speak with some of those same witnesses again. And those are the only ones that he would be speaking to.
Okay, so the state
Interviews that he was in, like it says 2017, like for impeachment if
I don't
necessary.
see a 20, are y'all looking at a different,
That's what I'm wondering because I don't see specific. It just says interviews.
I don't see a date or anything.
Okay.
Maybe if you've got more detailed exhibit and witness list.
Yeah, this has been an issue since day one. The vagueness, that to only list interviews, no year, no month, no date, not with who, when, what, where, why. In my personal opinion, if she cannot produce details that is of actual use for the defense, then it should be all out.
By now, maybe share that with us.
I do. It has some notes on
Okay.
there, so, but I will say it out loud if that's okay.
Okay, yeah, no, that's fine. So ours just says jail calls, pictures of infinity, interviews, social media, it doesn't specify.
Thank you. And I thank Mr. Shard as well for that, bringing that to my attention. So the Quindarius Zachary 2017 interview, if necessary, the Martinez Arnold 2017 interview.
Okay, so my concern was simply this: we're on the same page that he's not going to be commenting on interviews that he simply reviewed to bring himself up to speed before beginning his work.
It doesn't sound like it.
Okay.
These are interviews that he
Yes.
was a part of.
Right.
Okay. So maybe interviews, maybe not the best word, but
If he conducted it, if he was a part of it, then for impeachment purposes, he would be the one that would be impeaching the witness if necessary.
And would
Okay.
be only for witnesses that have already testified in
Correct.
case.
Yeah, yes,
okay,
ma'am.
so, yeah, so he's actually a little bit out of order. Well, no, I guess not. I don't know. So Arnold, Zachary, and whom else?
We have Kenya Morton, if we call her.
Yeah, I mean, we did. Yeah, I think Otto is correct here. Sprinkle said he was investigating since 2015, killing Thug in 2016. I think Otto is correct here. With the ADA Sprinkle. This is strange. Because if what Ms. Love says now is correct, then why wasn't that testified to in that hearing with him? But why am I surprised that the state chooses to not reveal things?
She has been listed as an alibi witness for Mr.
Okay.
Kendrick, so we may just let him put her up, but we haven't, she's on here, so we can still discuss items within that interview that may need to be dealt with or redacted. So that's 3.
All right, but yeah, so these would be only after they testify and for impeachment. If
Absolutely.
you don't just use the interviews to impeach them while they're on the stand.
Right.
Okay. And then, do we know whose jail calls?
We have Mr. Arnold's, Mr. Bradford's, Mr. Stillwell's, Mr. Sledge's.
Mr. Jingles is
I think
here.
we have dealt
Hello,
with the
Mr.
ones
Jingles.
from Mr. Sledge while he was. We dealt with the one, I think, that we were dealing with Mr. Sledge. And in Mr. Sprinkle's report, he referenced specific ones as it relate to Mr. Arnold, Bradford, and Stillwell. But what we'll do is go through those. That's another conversation we have to have and inform counsel for defendants, specifically those jail calls as well. So right now, what I'm looking at that we need to do from Mr. Sprinkle is go over the 3 interviews that potentially he could testify about if necessary, and just deal with any items that maybe need to be addressed, redacted, dealt with, and the jail calls from Mr. Arnold, Bradford, and Stillwell. I think we also had social media pics, but I think we got Mr. Bradford's social media pics in through Mr. Copeland. And we also got the social media pictures regarding Mr. Kendrick in already through one of the witnesses that have already testified. So outside of that, and I think we also got the post with Mr. Garlington and Mr. Williams with the we're not going back and forth in already. Those
All right,
are,
so there's no social media left that he'd be talking about then. Okay, so we can cross that one off. Okay. So going back then to page 1 with Mr. Zachary, have we dealt with everything we need to deal with for him? Social media, jail calls, and interview?
let me check our bucket that we provided. Hold on.
I can answer for the interviews. We have reviewed the interviews on the cursory level for bad character, those sorts of things. Now, my stance is that those out-of-court statements should not be played unless there's a proper foundation. So, of course, we still have that issue, and that won't be resolved until we hear what Mr. Zachary's testimony is. But we have reviewed those
Okay,
statements.
I thought
for
so.
The other stuff.
And jail calls and social media, yes or no?
You on the 2017, March, I believe, 3rd, 2017 interview of Mr. Zachary. There was one part that the Honorable Court, I think, redacted that I would like you to reevaluate if it becomes necessary. I understand it's all premature, but there's one section on one page that I would like to, I plan on, if it's ripe, cross-examining Mr. Zachary on it and then impeaching him if he says something different.
Okay.
I could give you a page
Do
if
you
you
know
want.
what day was this that week in August that we had the non-jury week that we would have reviewed that stuff? Okay.
Your Honor, can would the court please allow Mr. Steele to just tell us the statement or generally a summation of which one he's talking about?
Yeah, I'm sure he would do that for us. All right, I see Zachary's social media postings. We went through all of that. Was this wasn't one of these things on these big. This is Zachary, these things, no, that's, oh, yeah. Okay. So can you direct me a little more specifically now that I've got that in front of me?
Your Honor, the 2017
All right, hang on. The one I've got says 2015. Yeah.
If you need a copy, we can, I'm sure, give you one.
I would have thought I had a copy if we've already been through it.
Either that or Ms. Love Bullcrap.
Maybe I just looked at it online. I don't know. Mm. Would this have been in one of the evidence reviewer links, maybe, that the state sent?
This particular interview was not on evidence reviewer.
Okay,
It was, what's they were the MP3s? They were MP3 files and it was an audio. I honestly don't remember us playing the audio of this in court. I think we were mostly working off the transcripts.
is this, okay. So I've got his August 5th, 2015 interview.
That's the evidence reviewer
Okay.
one.
And then I've got a list that I think you put together was kind of page and line objections, that I
Right.
think was to the 2017 one.
That's the one that
Okay.
Mr. Steele is referring to.
All right. So I ought to have a transcript of it somewhere, but where that is at this point, I'm not quite sure.
It helps. It's a words express transcript. It's not one of the ones that the state produced. The transcripts, there's some look one way, some look the other one. This one is a words express transcript.
So it's not an actual transcript they provided.
And it's 262 pages.
All right, well, honestly, instead of me taking time trying to find it in some electronic file, if y'all got a copy of it that I can borrow, that would work as well. Thank you.
I don't see how that kind of transcript is admissible to go through.
This is the one that's 275 pages? Okay,
It
just because
says-
I know we have multiple transcripts by different transcribers, if they would just, if the court would allow them to send to the state as well, the one they're referring
Mr. Howe,
to.
can you send it to Miss Love as well when you hit send? Thank you.
Thank you.
Why do they have several examples of transcripts? Is it to send one off to the defense and keep one which they will use?
I'll make sure that the microphone on the witness stand is off.
Yes.
I think this might be the culprit.
As Mr. Short says, that is an Windows Express transcript. I more or less I have it via StreamYard when I do these cutouts from streams to present as videos. Then I get a transcript beside it just to make sure, okay, here is where I want to stop or start or something like that. Now, is it good? Yeah. Is it good enough to, instead of an actual transcript by a professional transcriber? I do not believe so.
I think that's the extra microphone on the witness.
Might be what's causing it. Okay. Law clerk. It's, okay, that's fine. That's fine. She's listening in, so. Ms. Persfield, when you get it, you know to just forward it to me.
And I just sent one. I think I found the one. And so I just sent it to everyone as well. So including the court, if that's the right one. They can let me know if it's not the one they're using.
Okay, well, I've got the one that Ms. Love just sent.
Where is that buzzing sound coming from?
That's June 14,
Or is it just
2017,
me
and it's
who
word
hears it?
expressed. So I think that's the same transcript.
Should be March 3rd. Hold on.
That was the date of the transcription.
Date of transcription, yes, okay. Okay, anyway, so now that we've got it.
If we could just get that date, that page and lines that Mr. Steele referred to so that I can go straight to it.
I know it to be page 39, lines 14 through 20. And this honorable court has preliminarily excluded that unless a foundation is laid. And I just wanted to, while we're talking about information, I just wanted to tell you that I was going to seek to lay the foundation. That's all.
Your Honor, unless my memory is incorrect, I don't think that this was a foundational issue. I guess the record will most accurately reflect what it was that it was excluded on, but I don't believe that this was an issue about foundation. Line 14 through 20 on page 39.
Well, I mean, if it was a foundational issue and you can lay the foundation, then that takes care of that. Okay. Okay. Ms. Love, do you have a,
I don't have my notes on that hearing that we had that Mr. Steele is referring to, so I don't have at hand the court's ruling or anything that I can make a definitive.
Why don't you have that? That's your computer in front of you. Why don't you have access to all the things? It's right in there. It should be right in there.
Statement about it on.
Or is it just
not there.
stalling again?
I'll have to search through that. I don't have those notes. I'm gonna check with the team.
Your Honor, I reviewed my notes from that day.
Okay.
For page 39.
what day was it? That would help me.
August 6th, 2022.
August 6th. Okay.
Court has stated to sort out the argument.
Say it again. Pick up the mic and say it.
Court asked the state to sort out their argument on this and get back to the court.
Well, there we go.
We may be on the same page. At the time, I was trying to figure out what was based on personal knowledge versus hearsay, and the state was arguing either personal knowledge or statements of a co-conspirator. So at the time, on August 6th, the state was seeking to admit this evidence. And so that's why they were supposed to circle back. But now as trials progressed, Mr. Steele is saying he wants to use it. So that's why the state was supposed to get back.
Okay. Does that ring a bell, Ms. Love?
A small one. I'm just going through our notes on that.
Okay.
I thought you didn't have those, but now you have them?
You just, oh, you want to keep it on, right? Leave it, just hold on.
Maybe you should turn off all the microphones instead.
Oh, I see.
Skipping ahead.
You feel it? Yeah. Okay, I see what you're saying.
Hey, Mr. Williams.
The state still think they, well, does the state still think they want that in? And if not, if the defense gets it in, do you have an issue with that or?
I'm reading, just the area before it and the area right after it,
right.
because I just want to make sure that we don't have an issue with it.
Okay.
It's also going to, and Your Honor, it's also going to some extent, rely on what else was kept out and what was kept in. So that's the reason I'm just searching through that portion.
Maybe, Judge, you should address Doug's motion to time limit the state's case. That's a thought. Well, Doug isn't there, I think, today, is he? No, I don't think Doug is there today. And we are almost back up to live. There we are. We caught up.
Your Honor, as to page 39, lines 14 and 20, they hearken back to page 38, lines 11. The context of that, I think, at the very least, starts on page 38 at line 11. And in that, the soon-to-be-called witness is informing the detectives about someone's opinion regarding who shot up a certain location. And that is listed on page 38, lines 11 through 12. All of that is speculation and the witness sharing with detectives what somebody else thought happened. And so as you get to lines 21 through 24 on page 38, when asked explicitly whether that happened, The witness says, I don't know. I don't know. So as we get further down, the witness is then asked, have you heard who may have done that? And the witness says he was locked up with the boy that was charged with it. And then ADA Sprinkle says, yeah, but I mean, do you think he did? Did he tell you that he did? The witness says, no, he said he didn't do it because the witness's cousin was supposed to make a statement on it or something, but it was the wrong girl. He said he didn't do it though. And then they get into, let's talk about, who shot Calvin Watts in Mechanicsville?
Right, and I think that's the part that Mr. Steele was saying, if he can lay the foundation, he wants to get into, right, Mr. Steele?
Yes, Your Honor.
Okay. All right, go ahead, Ms. Love.
Yeah, Ms. Love doesn't do anything that means something positive to the defense if she can help it.
Okay, see, I remember this argument. So if there's no objection from anybody else, I don't think that we have one to.
Yeah, she doesn't handle anything over or prepare anything that might be of benefit for the defense. That is why, I mean, the judge easily could have sent everybody home with orders to do this, and this, and we'll see you tomorrow morning. But it appears like she doesn't trust Ms. Love to do anything unless specifically ordered in court to do it. I wish I could skip forward, but I can't because we are live. Hey, Lakong Express in the house.
Okay, well, Mr. Steele, do you think that, is your plan to kind of ask some foundational questions to figure it out? Or do you think that it's already enough here in this transcript?
I think it may be enough, but I will ask foundational questions.
Okay. I mean, it seems
If
like,
needed, I'll ask him first about it, and I
Okay.
won't use the transcript. And then if he says something different, I'll say, did you say this? But I'll lay a foundation
Okay,
before
I
I
mean,
ask him the
that's-
first question.
And Your Honor, I obviously, if it's established that he has a basis for knowledge that does not consist of what somebody else might have said some other time that we don't know about, and he doesn't have personal knowledge of it, if it's not that situation, but he does have a basis for it, unless there's some other valid objection, then there's nothing that I can, complain about right now.
Okay. All right,
If there's an objection, we'll make it at the time, but I don't see anything right now.
okay.
What did
Thank
Love
you.
do? Oh, thank you. By the way, what did Love do for 3
Okay,
hours?
so
She sat on her
that-
ass and did jack crap. That is what I believe.
Back to Mr. Zachary. The interview would only be for impeachment, and have we gone through all of his social media and jail calls that might get
If Mr. Zachary
utilized?
testifies at all.
thought we had gone through his
I mean, I thought we had
social
to.
media,
just checking.
very least.
I mean, it looks to me like we definitely went through his social media postings and made the evidentiary determinations about that. But I don't know if we did jail calls or not.
I don't recall going through any jail calls.
Okay, so are there jail calls that you might intend to utilize? Isn't he coming up pretty soon?
When we-
This
Potentially,
is Bucky's.
Potentially.
potentially,
Yes.
okay.
And so I think that any of Zachary's jail calls would only be used to impeach Zachary if we needed to use Zachary's jail calls.
All right.
So right now,
Okay, so that would just be, if it happens to come up, we'll just roll with it at the time, I guess. Unless obviously if you know of something that you think is going to be an issue,
right.
then just kind of alert us outside.
So this is Miss Love preparing everybody for this witness will lie and I'm going to impeach him. So she knows beforehand, according to her, there will be lies.
The jury's presence,
I
but
think-
otherwise that'll just be a trial issue. Okay. And then the next witness on this sheet is Detective Thorpe. And I think y'all were gonna get together on,
So within adjusting witnesses, Squirrel Brain will take the stand. Yay!
the part of Mr. Kendrick's interview that might come in on,
Should we all agree on every time Detective Thorpe is on the stand, I will address him as Squirrel Brain. It will be on the thumbnail. It will be on everything. Right? Yeah.
redacting it for any potential Bruton issues? Did y'all get a chance to do that yet?
What my memory is, Your Honor, was that I know I said that I would be asking Detective Thorpe questions rather than trying to play all of that. And there were maybe portions where Mr. Kendrick talked about where he was on January 10th.
Okay, yeah,
2015,
no,
that
I'm
part
looking
I
now,
would
we
let-
did. Okay, so we just went through what was okay and what wasn't, okay. All right, so there aren't any outstanding issues then for him.
There was one thing, and I don't think that it's on here, but we were trying to put our finger on it within our team because we had identified a call between Mr. Kendrick and Miss Morton, where Mr. Kendrick, from our listening of it, seemed to be essentially trying to establish an alibi. And it seemed, I'll be clear, he said, I was with you. I was with you. And she says something to the effect of, yeah, you were with me. You were with me.
Mhm.
And I wanted to put Mr. Weinstein and his team on notice. He's not here. So, but Mr.
Well,
Howell,
yeah.
Mr. Howell
And his team.
and his team on notice that there is that call that is in the calls that were served in 2022, but we are wanting to identify the exact date and time to extract the MP4 so that they have it. But
All right,
we have it identified. It's just locating it in the large bucket of calls. But that is one that we know that we will end up playing.
okay. All right, thank you.
Probably beating this horse. And we're guarding the custodian of records. I know that we've probably beaten this horse, but there's still no stipulation regarding those. Nobody wants to stipulate as to, okay.
Doesn't sound like it. If anybody reconsiders on that front, please let the state know.
Nobody is interested in stipulating anything with Miss Love because of her history of being a lying liar who lies.
All right, so with Mr. Sprinkle, with the jail calls for Arnold, Bradford, Stillwell. The defense has them all, right?
Yes, and I believe that they're in the bucket of exhibits that we provided to them. I'm confirming that.
Bucket of be specific. That is the order from the court. Now, if I can be, I don't do this often, so bear with me. Where is it? There it is. All right, folks. My plan is to return to the United States for closing arguments, whenever that is. Rough calculation. It should be should be around May and June. If by that I have calculated in some delays for the prosecution. But you never know. So what I have is pinned my PayPal on the top of the chat on YouTube. And what gets in there is what I'm going to use to get in there. To get to the United States, get to Atlanta, be there in the courtroom for closing arguments. So if you want to support or sponsor that trip, PayPal. All right. That is the end of. Let's continue.
Yes, sir.
On the subject of jail calls, I know we changed, we went away from this topic, but the state mentioned Quindarius Zachary jail calls. From my recollection in the discovery, I don't believe we've ever been served Quindarius Zachary jail calls. I do know, I'm more certain that the state has never identified any sort of group of calls that maybe they may be interested in bringing into this case. So if there are some calls, if we haven't been served them, which I don't believe we have, I would ask that they be excluded. But if there are some calls into discovery, I would just ask that they're identified before, like, right when the state wants to bring them in, because we're going to have to review them. I know that Your Honor said, you know, when that comes up, we'll get to it and we'll discuss it. I just don't want to be in a situation where I'm hearing about a jail call of Mr. Zachary's for the first time in court. And then
Well,
having it,
certainly if y'all don't have them, then that's an issue, but let's find that out.
All of the jail calls have been served. Everything, all
That-
of our jail calls.
That's not the issue here. If you have handed it in discovery, they are in a lump of thousands of jail calls. And you were ordered by the court to specify which one you are planning to use.
For especially Mr. Zachary, which would have been those that we had around 2015. And I'll go look and point to specific things, but again, I have not identified any particular calls of his that we intend to use, and we wouldn't be introducing anything except for impeachment purposes. And his statements, the summaries of his interviews and transcripts of his interviews have all been provided.
Exactly, Samantha Yo. How does she know what they have? She doesn't even know where her notes are.
Obviously, people get on the stand and their memories,
Mm.
stuff happens with them. So
Okay, so do you happen to know like what tranche of discovery it would have been?
Judge, what I was doing at the moment Mr. Sharp asked that question, is I was actually trying to get the answer to
Okay.
the
All right, we'll give you a minute.
calls regarding Mr. Bradford and Mr. Arnold that are listed under Mr. ADA Sprinkle. And those were the January,
Bill Bradford and Arnold, we got that. I'm talking about Zach.
the court made the inquiry, so I was trying to.
Okay, so through Sprinkle, it would be Arnold, Bradford, and Stillwell, and that's it. Jail calls, potentially.
I believe it would be, those are the ones that we have identified so far. Yes, those are the ones that we intended. There were only, I think, 5.
You had 2 damn
And I
years and you're
paused
still
because I was
identifying?
now looking at, okay, there they are. So the January 11, 2015 call.
Let me remind you, folks. The state said mid-December 2022 to Judge Glanville, we are ready for trial. That's almost 2 years ago. If the jury selection had gone in 3 days for some reason, then this trial would have started in January of 2023. But here we are, and they still are going through the evidence. I don't think that constitutes ready for trial. They lied and lied again.
Call between Martinez Arnold and Javaris Bradford. The January 10th, 2015 call of Martinez Arnold at 7:42 p.m. The January 10th, 2015 call at 8:18 p.m. and the January 17th, 2015 call at 7:17 p.m. Those are the ones that we have provided that we intended to introduce through ADA Sprinkle. Now, as to the follow-up question that Mr. Sharp just asked about, and that the court inquired about, the Zachary jail calls were served in they are in July of 2022 under the jail calls folder.
Okay,
July 6, 2022
That's
and 9:16
thousands of jail
a.m.
calls. They buried that
So
in.
the first discovery service, and it's in the folder called Zachary, Quindarius.
all right, so that ought to help y'all locate it to review or re-review.
Could we just ask, as soon as the state identified, and I understand that they're saying for impeachment at this time, but as soon as they identify what they want to use, that they let us know. So we're not, I just don't want to litigate in court while the jury's here, just like.
The court,
And I appreciate that.
the court instructed us to alert the court and counsel outside the presence of the jury if that need arises. The court does have periodic breaks, and we intend to do that without.
I mean, I
Bullshit.
imagine it would be kind of hard to know before you know how he's going to testify, but is it a large volume of calls?
one moment to look at approximately how many. And to be clear, I know the subjects, I know the questions, generally speaking. I don't have a script of his responses. And so it is almost impossible to, at this point, predict which, if any,
Bullshit.
would be impeaching,
Bullshit.
because as everyone has witnessed, sometimes answers are non-responsive and not true at the same time. So it's just, I'll look through Mr. Zachary's calls to see if there's any one that contains something that's not in a statement or a summary.
Okay. Thank you.
That's not what she asked. How many? How many calls are there, Miss Love? That's the question you were asked. And no
All right, so
follow-up.
then I think that with regard to Mr. Sprinkle and what evidence would come in through him, we've gone through that. And then we've got cell phone custodians. I think we already talked about Mr. Burney. Which brings us to either Voss or, is it Wetzel? Is that how you say that? Weitzel? And I
And
assume,
it wasn't Boss. We had said Vanna Kelly. There was.
oh, right. What
And there-
Kelly?
Right,
Because
and
Voss is the one.
there is one outstanding matter before, I think, at least a week before. I don't have the notes that I had called about. I'm checking now to see if they've been sent recently, but there were. So the court had asked us whether she had provided a separate report,
Right.
and what the GBI told us that we informed counsel for the defendants is that she not just peer reviewed, but she verified the results that Mr. Voss obtained. And her notes were what I requested from the GBI. Normally they're pretty fast, and I'm just checking to make sure that they have not sent them and I just missed it. But I'm going to also follow up.
All
with a
right, so
call.
either, if you do have the email, just send that on, and if not, follow up. Okay. So that's all that's outstanding for that. Okay, Officer Atha, that's just, that doesn't look like anything particularly. You'll just pick which pictures are necessary. Same with Sanders. And Smith, that evidence already came in, right? With Sledge.
Yes, actually,
Okay.
she, that video from
Yeah,
that one, the one video did,
okay.
yes.
And then we've done Miss Latner's, and Miss Bell. And Pitts is just gonna be testimony.
Pitts's testimony and some of those pictures that we talked about earlier today, that if we've not sent a link over, that we're gonna be providing to them, those are the 1428 ADL Avenue pictures. If the court would indulge, can you confirm? We're so we have identified 9, I think, out of several from 1428 Adele Avenue that we intend to use.
Okay. With Pitts. Am I understanding you correctly?
Let me confirm.
Okay.
Just one moment.
All right, I'm going to give this another half hour. Then I believe we can do the rest tomorrow before trial resumes. Because I do believe I can get home a couple of hours earlier than usual tomorrow because I put in a lot of hours this week. And even if it is 3:30, if they continue to do this for another 2 hours, I think we can skip. We can do that in 45 minutes or something. But I will give you another half hour of this.
Just general, we're waiting. So Ms. Love, while we're waiting for your colleague to return, just let me generally say that with all of the crime scene photos, just make sure that you look through and narrow it down to what you need. I know that just as an example on the, and I did find you had given us a more detailed sheet with regard to at least, maybe the first 15 or so of the next witnesses, maybe more, with details about which evidence you were going to use. And I know, like, for one of them, there's like side view of XYZ gun, front view of XYZ gun, other side of XYZ gun, which may be significant for some reason. And of course, if it is, then let's use all of those pictures. But if it's not, and you can use one picture instead of three, just with the number of witnesses and the amount of evidence we have, if one will do instead of three, let's do one.
Yes, Your Honor. And there may be instances where we tender and, this many and publish two.
Exactly, just like you did with Miss Bell. All right.
Thank you.
And if you are going to tender this many, and especially with the crime scene text, just, hand them the whole stack.
Definitely.
Yes, sir.
Your Honor, while we have a minute, can I ask, can we go back to number 23 on page 6? It says
Ye-
Tyrone Dennis.
Yes.
The second check or second box thing says overall investigation of crimes of YSL between January 2015 and December 2015. I don't know what exactly the state means by that. Summary witnesses, my understanding, are frowned upon. We missed Investigator Dennis previously, when Judge Glanville was the judge in this case. There was a easel with pages being flipped where he was listing all these different shootings and saying what was gang related, what wasn't gang related, or really just what was gang related. And kind of going through a timeline of a bunch of different acts of violence. I don't think at this point, if it's targeted to something, I'd be interested to know what the state is trying to get from Investigator Dennis at this point. But just like another recap of everything that was going on. I mean, we objected the first time. And we still don't believe it was appropriate, but to do that again, it's just, we're kind of retreading the same summary of this case. And the jurors, they're smart, they get it. And so, I just don't think that would be appropriate.
Okay, well, I'll inquire. I'm sure you're not gonna just put him up for a recap of what he's already testified to. What's gonna be new?
Your Honor, we're not putting him up through for a recap. What we gave on that sheet of paper was a generalization. If, as for instance, he was allowed to talk about his investigation. He was qualified as a gang expert, and many of the incidents that he investigated, he was able to.
Yeah, this is one of the things in Georgia that I really don't agree with. That a person can be both a fact witness and an expert witness. For me, that is self-promoting. That his word or her word somehow means more when they are talking about cases. I do not get it at all. And then you had Miss Gaither, who they did the Daubert hearing in front of the jurors. And for me, that is so prejudicial that I would equal it to somebody pleading the fifth on the stand. But apparently, in Georgia, it's allowed.
Gain information pertaining to some of the facts that he testified about. He was some of the things that he was able to testify about. He also actively, like I said, participated in the investigation. So he, as a fact witness, was able to testify about those things as
With
well.
no reports.
As the court sees what the court doesn't know or wasn't there when he touched on the fact that after Donovan Thomas's murder, they went back and they saw that there were incidents that occurred that appeared to be act and reaction from certain groups of people. And then after the Donovan Thomas murder, that there were a series of retaliatory shootings. He did not go deep into them. There were incidents that were listed that we are now presenting evidence of. At the time, there were objections to him talking about his investigation into those crimes. We alerted the court. We're going to put up evidence of those crimes. This particular one we did today is one of them.
Right.
So in as much as he gave a broad overview of, what things they saw occur. And that is at this address, there was a shooting. Then there was this shooting at this address. To the extent that there are details that are going to be brought out or that are challenged on cross-examination. Those sorts of things that were not ever talked about before will be talked about with Detective Dennis this go round. This will not be a rehashing, of a summary. That's not necessary. That would be a waste of time. This is going to be information that either he's not testified about or someone challenges another person on cross about. I don't think that at this point we can actually say, hey, this is all the stuff that we're going to talk about. We do know that it's going to encapsulate that area, that span of time that we listed for the defense in the court on that sheet.
Well, Your Honor,
Yes.
let me say this. I'm seeing these 4/28/15 shootings. I'm seeing on the state's list here, they're saying committed by Demekion Garlington, Antonio Sledge, Quindaria Zachary, and Shannon Stillwell. There is no evidence other than Mr. Zachary in his proffer, trying to get better sentence, saying that Mr. Stillwell was there. There's absolutely no evidence, no phone records, no other witnesses, no ballistics that link to Mr. Stillwell. There is nothing that puts Mr. Stillwell in that case. My concern, and he wasn't charged either.
Okay.
What I don't want is, I don't know what Mr. Zachary, where he is, if we're gonna hear from him, if we're not. But what I am going to have a motion if somehow Mr. Stillwell, through investigator Dennis or some other witness that has no firsthand knowledge of anything, starts trying to bring my client into the 4/28/2015 shootings. And from the discovery, the only person that says that is Mr. Zachary when he was, trying to get himself out of trouble. And if Mr. Zachary says that, I will deal with that on cross-examination. But until Mr. Zachary says that, investigator Dennis should not have anything to say about that.
All right.
Your Honor, the state, we are well aware of what the rules of evidence allow and don't allow. We will adhere to those. And as it relates to the evidence that we tender to prove the facts of this case as relates to each of these defendants, we will comply with and follow the rules of evidence. And I think that at this point, to efforts to sort of restrict what someone believes we may do is, at the very least, it would be a waste of time. It would make no sense for us to try and introduce through a witness we intend to put up a statement through someone else, through Detective Dennis, a statement of Zachary before Zachary ever testifies. That's wrong.
All right,
We're not
well,
going to do that.
I mean, that's
And so-
good. I don't mind somebody alerting everybody to that as a potential issue. And I appreciate that you say that, of course, you're not going to do anything like that. Okay. Yes.
On that, over objection, retired Detective Dennis did testify as what I'd call a summary witness.
Uh-huh.
But the court needs to know that we never received an expert report for some of these people, not Miss Bell, who just testified, and those reports that we have on that incident on April 28, 2015, that found her to unfortunately, tragically be shot. A lot of what the Detective Dennis previously testified is total confrontation clause. I don't even know who he spoke with. He just spoke with people, interrogated people, interviewed people, people called them up, CIs. I have no idea if there was hope or benefit. And I think that's what Mr. Shart is getting to, because that's already happened. It's over objection, and I don't want it to happen again. And also, summary witnesses are not favored. That's United States versus Perry, P-E-R-R-Y. And that's 35F 4th. It's at 293. It's in Division 3, 5th Circuit, 2022. Specifically, again, we caution the government not to rely on improper summary witness testimony. So I would also join in that same objection. And I understand it's a pre-objection, but
Okay. Thank you. And actually, I think that Ms. Love had shared with everybody, she had gotten through about, I don't know, it's not numbered, but 7 or so pages witnesses at the time, they were 81 through 110 with more detail than what's here of exactly what she thought the evidence was going to be at the time she put it together. And for Detective Dennis, he's on the last page of that. She's got listed the specific evidence that she, at least at the time she was putting it together, thought he was going to be testifying to this time around. And it doesn't, other than the PowerPoint, which has essentially been ruled out, it doesn't look like it's kind of summary testimony. Is that fair, Ms. Love?
Yes, and also I think that as I'm getting updates from team members who are also signed on, that in the Dropbox that I believe that we provided, we have, with even more specificity, photographs of Zachary and Copeland with guns, found at the Dunbar Center and at the Zachary arrest. And I think that this is something that has already been touched on. It's not, the court is correct, in short.
Okay.
We've been more specific.
Okay.
That rests solely on that Ms. Love is to be trusted. And she isn't. If I were a cynic, which I am, I would assume that Detective Dennis will be prepped to give an answer. Maybe not to that Ms. Love doesn't have to ask the question, but in his answer, some crap will be told. Happened last time.
Okay. Sure. All right. So did you come back with further information? I think we had paused on something and
We did, okay. So we have from Adele Avenue, there are several photos that we are still narrowing down that we got today. We will provide both all of those photos as well as the ones we
Got them
intend to
today?
tender as evidence. My notes say that they are in the Dropbox link that 88 Atkins shared under CST Turner, but I don't know. My notes don't say that we have or have not sent them over to counsel for defense and to the court. So I'm confirming that.
Okay.
We have 15 additional photos and a floor plan for 1903 Drew Drive that is being sent over shortly as well. Let me confirm whether that Dropbox link was shared internally or with everyone.
Okay.
Just a moment.
To help. There,
without the, can't hear you without the mic. I'm sorry.
if they're looking for a recent email, I'm just trying to help. We haven't received anything from the prosecution team.
Okay.
I am being informed that the Dropbox link that everyone has been updated with those items.
Oh, okay. So,
So it wasn't there, but it is now. You sneaky.
just, can you tell which Dropbox link it is? Because I know there are several.
The one with the 30 witnesses that has this particular witness on it.
Okay. Okay, great.
So they
right,
updated
thank
it
You're
and
welcome.
didn't tell it until 4th to now.
All right, so we were at what is numbered on this order of proof and exhibits list. We were on witness number 21, Officer Pitts, and that's, I think, when we stopped to sort out the issue with the new photographs from Adele Avenue. And so moving on, we just talked to the next page, witness 26, Detective Dennis, we've just talked about. And I had written down from when we talked before, the number 87LL, was that the PowerPoint that we have already dealt with? I don't know.
What is the court's note regarding 87?
87LL or 871L? I should write more detail in my notes.
1 second, Judge.
You know what? It was the PowerPoint. We've dealt with that. So that's fine. Okay. All right, so turning the page, we've got Mr. Arnold, his plea agreement, potential jail calls and social media, and the jail calls would again only be, y'all are having him testify, planning to?
Correct.
So that would be, is that gonna be anything other than potential impeachment?
No,
Okay.
I think that.
And those would have been the same jail
the
calls that were listed under Sprinkle also.
Well, yes, I was gonna say, yes, and the one in particular that I'm thinking about as I play it in my mind, whether it would be this particular one on January the 10th would be considered impeachment. It was right after the murder of Donovan Thomas, and it involved Mr. Bradford. A call from Mr. Arnold to Mr. Bradford.
Okay.
So it's a call that the state may tender on its own. I think it's one that the conversation needs to be heard. I think it's something that can't be captured in a
Okay.
examination and a response.
All right. So is that one that we need to litigate anything about? Yes.
It's-
The defense thinks so,
It-
so I guess we need
okay.
to litigate it. There doesn't sound like there's agreement. Okay, is that something we can do now?
I just, if I could hear the specific objection so that I could respond appropriately. Mr. Whomever said that is correct. It is a 15-minute call, but
Okay.
I believe.
I'd ask the court just to allow us to know specifically the objection to it since the call has been identified.
Okay,
If I'm thinking of the right call, there's different people. Mr. Arnold is in custody, by the way, Your Honor. He's arrested on or about the 6th day of January 2015 outside of Club Crucial. You heard about this fight at Mr. Copeland. He's arrested outside. And I believe he's charged with either a small amount of marijuana or a gun or something to that effect.
okay.
It's now the 10th day of January 2015. It's approximately, my memory is 7:42. I may be wrong. And it's clearly a collect call. If the voices are identified the way the state says, it's Mr. Bradford at first and Mr. Arnold. But then there's another woman who's on the phone, who I am not going to stipulate who it is. And she gets on the phone and supposedly says something potentially about Mr. Williams. I am objecting to that portion if that person's not testifying. The person, I believe it is, but I'm not stipulating, is Miss Morton. And I heard today that the state said that they will wait on the Honorable Douglas Weinstein to call Miss Morton to promote the alibi defense for Mr. Kendrick. So I would move to exclude that portion. There's other portions, and I just have to get my notes, Your Honor, but I can do that, that are not relevant. They're talking about, I don't know, the jail food, or I don't know. I don't want to make specifics,
Sure.
but it's nothing to do with anything happening in our case.
Okay.
So understanding, at least I'll respond not to the jail food, but because that was at most a few words, but this is, we believe, calls between co-conspirators who are Mr. Arnold reaching out at first. I believe he may have initially had one purpose for reaching out, but the conversation turned to an alert or an informing of the current status of something that had just occurred. We believe that the thing that had just occurred that is a part of the larger conspiracy that is count one is the murder of Donovan Thomas. This is Mr. Arnold reaching out to Mr. Bradford, Mr. Arnold asking, you know, what's up, how things are, how are y'all doing? And Mr. Bradford saying some shit just occurred. He's, we believe, being intentionally selective with his words. And Mr. Arnold is asking where other people are. Miss Morton gets on the phone. Mr. Arnold specifically asked where Mr. Williams is. Ms. Morton says to Mr. Arnold, "Hey, Goldilocks." Mr. Arnold at some point had his hair dyed blonde gold, but she references him. And at some point, of course, Mr. Arnold asks, just to speak to the idea of we don't know who it is, Mr. Arnold asks Mr. Bradford, who is that? And Mr. Bradford, I think, says Bushi. And as they are apprising one another of what is happening outside the jail, as they are apprising Mr. Arnold of what's happening outside the jail, we believe that this whole conversation is a conversation between co-conspirators serving to inform each other of the current status of the conspiracy, which therefore furthers the conspiracy itself. It serves to maintain a certain level of cohesiveness among them. And each one of the people who are taking part in the conversation are persons, we believe, who have just had some involvement, if they did not switch cars with, provide transportation for the people we believe are involved in the murder of Donovan Thomas. They are advising each other of where.
That's all it is. Gossip. Gossip, and rumors.
The participants in that activity are at the moment that the inquiry is made. And I think I said that Mr. Arnold asked for Mr. Williams. It may have been that he asked for Mr. Kendrick. So that's a mistake on my part. He asked where Yak was. And I think that in responding, where one of them was Mr. Arnold was told that they were either with Mr. Williams. There was a reference to their current locations. And at this point, the entirety of the conversation, we believe is one that is informative, one that falls squarely under the co-conspirator statement category. So at the very least, there is that. We do intend to inquire of Mr. Arnold about that. I don't know what he's gonna say.
Okay,
But so it has two, we believe that it would be introduced in one of two ways.
So if Miss Morton is the person who answers the question of where Mr. Kendrick is and says where somebody else is as well, are you contending that she's an unindicted co-conspirator?
Oh, she is, we believe that she is, yes, an unindicted co-conspirator. She is,
Yeah. Unindicted co-conspirator, the absolute vague crap that should never be allowed to be even said in a courtroom. Is it a co-conspirator? Yes. Why isn't that person indicted? We don't have any evidence for it, so we will call it an unindicted co-conspirator. This is so stupid.
not saying that she, participated in the murder of Donovan Thomas, but in as much as her actions this night and what she does later on, I think the conversations that she has with Mr. Kendrick, we won't be trying to get into what she told the police, but I'll just tell the court, she tries to provide an alibi initially. It's sort of, she's lying for Mr. Kendrick later on, when presented or confronted with the surveillance footage. She's kind of coy and, saying, I don't see who is that? I don't see that. So she, yes, is a part of the conspiracy in that sense. She's not indicted. But when we're looking at the broader conspiracy that involves YSL and protecting its members and carrying out its purposes, she is a part of that. She's not indicted.
Associate of YSL?
Yes.
Your Honor, I would ask that this discussion be tabled for another day. Mr. Weinstein is more on has the details of this conversation and this evidence.
Okay, so I am going to need evidence other than, like, what the state's evidence other than this one conversation is to establish that she's an unindicted co-conspirator. I assume, Mr. Steele, that would be your objection?
I have a series of objections under 24-8-801 D2E. And specifically, and a good case I think is Stafford, STA-FFORD versus State, 312, Georgia, 811. It's in Division 5A, as in Elisa, 865 Southeast 2D, 116, 2021. And Your Honor, my position is going to be just the law, like you've been articulating. The state first has a requirement by a preponderance of the evidence that a conspiracy existed, and which is what I focused on and what the court just focused on, that the Honorable Court focused on, that the conspiracy included the declarant and the defendant against whom the statement is offered. And the statement was made during the course and in furtherance of the conspiracy. And when you hear the recording, you may make determinations that one, if it is Miss Morton, if someone can identify her voice, that she is not a part of the conspiracy, and that would break the chain. And two, it may be a quote spilling of the beans, because the entire conversation is nothing to further the conspiracy. If anything, and I'm not saying there's any conspiracy, but if anything, it's very vague and something happened. And I'm not saying that personally, I'm going to argue that it does not further conspiracy. So there's many different objections that I will have.
All right, so that is something we need to come back to.
Yes, Your Honor.
And
just-
so far, I apologize.
Go ahead.
So far, to my memory, and please correct me, someone, I don't believe there's any testimony about Miss Morton in this entirety of the case. That's my belief. And the state just said that they potentially, I know they could change their mind, but potentially not going to even call her.
I'm not certain what, when Mr. Steele says there's no testimony about Miss Morton, I'm not sure if he means there's not any that's been presented, or he hasn't seen where any could be presented in discovery, because
I think that any has been. Yeah, he's nodding his head in affirmation.
What?
Okay, well, I mean, as long as it will be.
yes, and I know that we've already,
But it's not if it will be. What if it's not? What are you going to instruct the jury? Remember that thing the prosecutor asked and was answered 3 months ago? You have to forget that. This is so stupid.
shown
Now this is
the
interesting, so I'm
surveillance
going
footage
over
at the
time a
gas
bit.
station. This is just in terms of the idea of Miss Morton. She's the person getting out of Ariel Bax's car, getting into the Pontiac Bonneville that Javoris Bradford is driving initially, that then Diamante Kendrick gets out of and walks to another car and comes back and ultimately gets into the driver's side of.
This is the video from the gas station that's the night of?
Yes.
Okay. And
Miss
it's allegedly like immediately after?
Oh, it is. It's immediately
Okay.
before. It's about
Immediately
6
before.
minutes before Donovan Thomas is
Okay.
gunned down 100 yards away.
Okay. And she is identifiable?
Oh, she's identifiable, identified.
All right, well, that sounds like that might do it, but we'll circle back on a day when Mr. Weinstein is here at Mr. Hell's request. And I assume there's gonna be somebody that says, that's able to testify that her kind of street name's Bushi.
Yes.
Okay. All right. Thank you. So that is that jail call. And then what about Mr. Arnold's plea agreement? Is there a similar kind of factual acknowledgements as there was with Mr. Sledge?
There is with each defendant that pled guilty. And also, as I was over the time that the court broke from when the jury was here, I was going through my emails to try and do finish up the collection of correspondence at the time that I was speaking with Mr. Merchant, his attorney, to tell her he's coming up.
Okay.
And I found that same series of emails that I'll be sending to the court
Okay.
and to counsel for the defense regarding her requested changes,
Okay, well,
or he is, or however.
I'm gonna hope that we don't end up calling another attorney to the
I don't-
stand.
Judge, I didn't want to call the first one.
I didn't really go that well for you ultimately, I don't think.
Well, see. You'll see.
Okay. All right, so in the event that the same or a similar thing ends up happening, I guess I'm gonna circle back, when we were talking about the admissibility of the factual acknowledgements plea agreement before, and I ruled that it was admitted. And Mr. Sharp said, okay, well, that may be, but there still may be some continuing witness issues. And I said, well, we'll deal with that later. I was thinking about that yesterday. And I also think that there are continuing witness issues with that.
I don't disagree with the continuing
Okay,
witness
so,
part.
basically that never got displayed to the jury because we only admitted it after the jury was gone and the witnesses were both off the stand. So really, that's not anything they'll ever see.
Actually, Judge, I tendered it, while I think I tendered it in front of the jury. And at the time, there was an objection.
Right.
And I believe that to the extent that the court admitted it, it can be published. It can go back.
Okay, well, I don't know who you would, I guess you don't necessarily need a witness to do that, but.
And since the court did bring that issue up, there was another matter regarding the factual acknowledgments that I wanted to bring to the court's attention.
Okay.
There was the testimony from the attorney regarding two portions of the final document, specifically as the only two portions that were taken issue with.
Right.
One being number 3, which the court remembers,
Mhm.
but number 8
Right.
specifically.
Mhm.
And of course, the argument will be made. There are certain arguments that are right for that, but the thing about number 8 that I wanted to bring to the court's attention is that number 8, and this is not something I felt was I didn't feel it was something to go back and forth with the witness on the stand about. He testified, his memory was, he didn't remember seeing it.
Right.
But number 8 was a distillation, a pulling apart of a iteration, the one right before it, that he took issue with. And the reason the state tendered states 460 Yankee as well as 452 and 453 is that 452 contained the statement that 460 Yankee addressed, and in 460 Yankee, in as much as there were certain things that were not contested but clarified, but the personal knowledge part is a specific thing that wasn't denied, but that was implied. And I'm just saying that instead of having what the state did, what I know we did, and when Mr. Wright says he doesn't remember, that's fine.
Mhm.
But when we provided to him the document that had it pulled out, there was not, I don't know how he says he didn't see it, but there was not any indication from anyone that was incorrect. That wasn't just taken out of the air. That
No,
was,
I know that it wasn't, but we have already talked about that. I know what the state, I know and understand how it is that the state got to and believed that given the comments he made, you all could say, well, okay, still whether he knew it was planned or not, he still knew it happened and that they were responsible. But it doesn't actually say that in the iteration that got changed. And so that might have been the state's understanding of it. But, it is what it is. And
and
you didn't explore that with the witness anyway. So, at this point,
Too late.
obviously that was a protracted examination
was.
that I did not want to make more protracted, but I do think that in as much as there is
Just
an
give it
attempt
up.
to
Give it up, Ms. Love.
convince the jury that
Stop wasting time.
essentially these are made up things that the
That you
state
just
put.
slipped it in.
Yes,
Well,
I
mean, Miss Love, then put somebody else on the stand, but I mean, you telling me this, I mean, it doesn't do any, I mean,
the reason that I was telling the court that was not to try and completely relitigate an issue, but as to the section that
403.
dealt with his response,
403,
not the whole response, not that then it's 460.
403,
But I would ask if the court
403, 403.
might consider reconsidering just us putting in that one part that he responded to, the way that he responded, and then the ultimate
okay.
version, so that at least before the jury is where that came from, since there has been this continued effort to convince them that we make stuff up and we just, out of thin air.
Well, I mean, you're the one that decided to put him on the stand.
I don't regret that, or I don't think that that's the problem that maybe, obviously minds can disagree. I don't think that that's the problem.
Okay, well, if it were as clear as somewhere in the earlier version was the statement, I personally know that members of YSL were responsible for this murder, or whatever it said in the ultimate version. If that were in the prior version, that would be one thing, but that's not in the prior version. So I'm not, I mean, I have thought that issue through.
Yes,
And I understood that to be your argument yesterday or the day before, or whenever it occurred, the day before and yesterday. And I just,
Yes, Your Honor.
okay. Appreciate you giving.
Yeah, it didn't go so well last time. You put a lawyer on the stand.
I
And
know
Miss-
you.
And remember, Miss Merchant lectured Judge Glanville to the point. Yeah. I actually hope that Miss Love puts Miss Merchant on the stand. That will be for streaming reasons really interesting. Oh.
So anyway, with regard to if the same or something similar comes up with some other of these co-defendants who have pled, then
No, she's not on the list. She
just be aware that, and it sounds like we're all in agreement that it can't go out to the jury anyway. So if you want them to see it and it does get admitted, you'll need to display it at that time. And if you come up with a way to publish this other one, then let me know.
Okay, okay, thank you.
Okay.
Yar!
All right, so then if we turn to the next page,
All right.
we've got,
This is a decent cutoff point because I already went 15 minutes over. Folks, I need sleep. I need sleep. And I need it now. So I'm going to send you all over to Catnot Williams, and then I'm logging off, going to bed, because in way too few hours, my alarm will go off. So, folks, thank you all for being here. Thank you for allowing me to do this, trying to translate and explain this faster clock of a trial. But I will see you all back here tomorrow. I believe I can get through the rest of this in 45 minutes or less. So 8:15 tomorrow is my goal to start tomorrow. All right. And folks, hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. Okay? See you tomorrow. Bye-bye.